Minash-shaytanir-rajim. Bismillahir-rahmanir-rahim. Dear students, our today lecture topic is conciliation. First of all, we will describe the meaning of conciliation. The term conciliation is used to define that alternative procedure of settlement of dispute with the help of some third person without going to court and without following the strict rules of procedure. The third person helps the parties to reach to an amicable settlement. The simple meaning of conciliation is the settlement of disputes outside the court by a simple process by which the discussion between the parties are kept going through the participation of a third person. The third person helps the parties to reach to an amicable settlement. It is a process by which the discussion between the parties are kept going through the participation of a conciliator. The third person is called conciliator. So there are three parties in conciliation: two parties which have a dispute between them, and a third party, the third person who tries to resolve the disputes between the parties, and that person is called conciliator. Now we come to the definition of conciliation. Halsbury Laws of England define it as: conciliation is a process of persuading parties to reach an agreement. Wharton's Law Lexicon defines conciliation as the settling of dispute without litigation. Beazley and Whitley have also defined conciliation as settling of dispute without litigation. So, if we look at the above three definitions, we will come to the conclusion that conciliation is a process to help parties to reach to an agreement without going to court and to settle their disputes without litigation. Now, we will come to define that what is the scope of conciliation. Conciliation proceedings can be used to solve any kind of dispute, whether contractual or non-contractual. By contractual, we mean when there is a contract between the two parties and one party did not act upon the terms of the contract, and non-contractual means that there is no contract between the parties and there is some transaction between the parties and they come to a dispute. So in both kind of disputes, contractual or non-contractual, conciliation is an instrument to settle the dispute with the help of a third person without going to the court and without litigation. Now, dear students, the point is the application of this procedure. The question is where or in what kind of disputes conciliatory proceedings will apply. So there are a lot of examples of it: marriage disputes, or we will call family disputes, labor disputes, commercial disputes, business disputes. First of all, we define marriage disputes or family disputes. In marriage or family disputes, the dispute will be resolved through conciliation without going to the court, and it will affect the parties to settle their disputes and help the parties to settle their disputes without going to the court. Labor disputes, a dispute between labor and their employers, companies, or in factories. So it will always help through conciliation. Commercial disputes is another example. Business disputes. In everyday business, there are a lot of disputes which arises between the parties, and the best way is to resolve the dispute through conciliation. Now we come to the salient features of conciliation process. First, independence and impartiality. The conciliator should be independent and impartial person. He should assist the parties in an independent and impartial manner while he is attending or attempting to reach an amicable settlement of the disputes. Second, fairness and justice. The conciliator should be guided by the principles of fairness and justice. He should take into consideration, among other things, the rights and obligations of the parties, the usage of their trade concern, and the circumstances surrounding the dispute, including any previous enmity or dispute between the parties. Number 3, confidentiality. The conciliator and the parties are duly bound to keep confidential all matters relating to conciliation proceedings. Similarly, when a party gives the information to the conciliator on the condition that it be kept confidential, the conciliator should not dispute that information to the other party. Next, disclosure of the information. When the conciliator receives the information about any fact relating to the dispute from a party, he should disclose the substance of that information to the other party. The purpose of this provision is to enable the other party to present an explanation which he might consider appropriate. And the most important ingredient of conciliation is cooperation of the parties with conciliator. The parties should in good faith cooperate with the conciliator. They should submit the written materials, provide evidence, and attend meetings when the conciliator requests them for this purpose.